Attention seniors, a quiet court trick is spreading, and it can gut your rights fast. Starting this spring, one ruling can vanish if lower judges rewrite it. Last week, a 72-year-old named Patricia in Seattle lost $9,140 overnight. She heard her case was reconsidered, yet the outcome stayed the same. She cried because it felt like the system was laughing at her. Stop for 5 seconds. If you're not subscribed, you're gambling with your future rights. The next update I post could help you avoid an expensive mistake, but you won't see it unless you're subscribed. Click subscribe now, then stay with me. You've been told the Supreme Court is the final referee. When it speaks, every lower court is supposed to follow. That's how one constitution can protect you in every state. But right now, some courts are using word games to dodge rulings, and that should worry you because it hits real people first. Here's the basic problem, in plain English, with no legal fluff. A tragic police encounter leads to a lawsuit about excessive force. The family loses, appeals, and finally reaches the Supreme Court. The Supreme Court sends the case back with clear instructions. Then the lower court obeys on paper, but repeats the same result. The trick usually looks like this. The Supreme Court bans a narrow test that ignores key context. It says judges must look at the whole situation, not one snapshot. The lower court then invents a new shortcut that sounds compliant, and your rights end up weaker, even after a high court victory. Let me tell you about Patricia. She is 72 years old and lives in Seattle, Washington. She volunteers at a food bank and drives older neighbors to appointments. One evening, she witnessed a stop that turned deadly in seconds. Her nephew's estate later faced a legal wall, costing $9,140. 2 months later, Patricia got a call from the family lawyer. He said the top court rejected the freeze-frame way of judging force. Patricia felt hopeful because someone finally noticed the unfairness. She told her sister, maybe this time they'll look at everything. That night, she slept better than she had in a year. Then the next update hit like a punch. The appeals judges didn't ask for new arguments from either side. They didn't hold a new hearing or invite questions from attorneys. They wrote a quick new opinion and still dismissed the case. Patricia stared at the email, feeling sick and strangely powerless. The new opinion used fresh words but kept the same escape hatch. It said a moving vehicle always creates deadly danger for officers, so it treated the case like an automatic category, not a real story. The family's evidence about safer options never got real attention. Patricia felt angry because always is not the whole picture. The family's options narrowed fast after that. They could ask the Supreme Court to step in again, but doing that cost time, stress, and serious legal fees. Patricia helped raise money and wrote letters to local newspapers. She learned a hard lesson about how fragile final decisions can be. Quick pause. What state are you watching from? Drop your state name in the comments right now. Rules can differ by region, and I need to know your location. Your comment also helps this reach people who need it. Now you might be thinking, that's just one bad case. But this isn't about one family, one officer, or one courtroom. It's about whether a promise means anything after a clear ruling. If lower courts can dodge instructions, the entire ladder breaks, and you're left with different rights depending on where you live. Here's what frustrates me, and it should frustrate you too. This kind of dodge isn't loud, so most people never notice it. There's no siren, no headline, and no public vote. A few sentences in an opinion can erase real accountability, and the public only learns years later after damage is done. Let me tell you about Thomas. He is 74 years old and lives in Atlanta, Georgia. He's a retired mechanic who still fixes cars for neighbors. His grandson was involved in a stop after a minor traffic issue. The family later faced bills and losses totaling $12,680. At first, Thomas thought the courts would at least hear the facts. He assumed judges would ask, was deadly force truly necessary? But the first judge used a narrow rule that ignored the buildup. It only asked what danger existed at the trigger moment. Thomas felt confused because decisions before the shot seemed important. After the appeal failed, the family pushed higher. The Supreme Court surprised them with a strong, unanimous message. It said, you can't judge a crisis by cropping out the lead-up. It told the lower court to apply a whole-picture approach. Thomas felt relieved, like someone finally turned on the lights. Then the anger came, because the lights were quickly dimmed again. The same appeals panel acted like it understood the new rule. But it created a new automatic idea about cars and danger. It treated driving away as a deadly threat in every case. Thomas said, that's a shortcut, not real judging. The family had a limited window to ask for review again. They had about 3 weeks before the paperwork deadline. Thomas helped pay for filing costs by selling an old tool set. He didn't want revenge. He wanted honest rules that apply to all. The case became less about one event and more about court power. Real quick, if you're getting value from this, hit the like button. The algorithm pushes videos with strong like ratios to more viewers. That means more seniors learn this before it hits their family. It takes 2 seconds, so like the video now. Now let's talk about the second layer of the problem. Courts often protect officials with a shield called qualified immunity. It can block lawsuits unless the right was clearly established already. In practice, it can turn real harm into a dead end. And clever compliance makes that shield even harder to challenge. This makes me angry because the game is tilted toward insiders. Families must follow strict rules, tight deadlines, and complex procedures. But courts can change their reasoning without asking new questions. They can reword the same result and call it following orders. That feels like two different systems, one for you and one for them. You should also know this problem spreads beyond police cases. If it happens here, it can happen in speech cases too. It can happen in property disputes, religious disputes, and voting fights. A lower court can claim loyalty while quietly shrinking a ruling's reach. That's how national rights become local bargains. Let me tell you about Barbara. She is 70 years old and lives in Denver, Colorado. She's a widow who keeps careful records for every bill and payment. Her brother died during a tense stop after a minor warrant mix-up. The estate faced costs and setbacks totaling $10,135. Barbara watched the case crawl through court for years. The first ruling focused on the officer's fear in a single second. It ignored choices that made the moment dangerous in the first place. Barbara felt blamed, like the family asked for the situation. She started doubting the idea that facts truly matter. When the Supreme Court stepped in, Barbara felt cautious hope. She thought, now they must look at everything, start to finish. The High Court didn't pick a winner, but it fixed the rule. It demanded honest context, not a cropped video frame. Barbara told her niece, this is what justice should sound like. Then the lower court did something that stunned her. It kept the same ending, but swapped in a new, automatic reason. It said certain actions always create deadly danger by definition, so it treated the case like a category, not a unique event. Barbara felt like the court replaced judging with labeling. Barbara's family didn't have endless money or energy. Every month meant more stress, more paperwork, and more lost workdays. They had to decide whether to petition again or walk away. Barbara said the worst part was uncertainty, not even the expense, because rights without reliable rules are just words on a wall. Think of someone who needs this information right now. Your parent, sibling, friend, neighbor, or the veteran down your street. Someone who could lose protection because a court rewrote a ruling. Share this video with them immediately and text the link today. Don't wait until later, because deadlines don't wait. Now I want to give you a hopeful angle because you need it. The Supreme Court has been warning lower courts about fake obedience. It has criticized rulings that follow the name but break the purpose. When the High Court speaks clearly, it expects real follow-through. That matters because it shows this issue is on the radar. Hope doesn't mean you relax, though. Hope means you pay attention and act while the window is open. A petition deadline can be weeks, not months, in some cases. And once a case is closed, reopening it can be nearly impossible. So the public pressure has to come early, not after the fact. Let me tell you about William. He is 76 years old and lives in Charlotte, North Carolina. He served in the Navy and now helps with neighborhood safety meetings. His cousin was killed during a stop tied to a small traffic dispute. The family's documented losses added up to $14,260. William thought the courts would treat the Supreme Court like a boss. He expected the lower judges to ask for new briefs and arguments. He expected a careful review, since the rule had changed. Instead, the panel issued a fast decision without fresh input. William said it felt like a door slammed before anyone spoke. The new reasoning sounded polite but acted harsh. It said, fleeing in a vehicle automatically threatens officers and the public. That phrase, automatically, is where the trouble lives, because automatic rules erase differences that can change everything. William said, that's not the whole story, and they know it. The family considered asking the full appeals court to review, but that request can be denied with silence, and often is. When no judge even asks for a vote, it sends a message. It suggests the system is comfortable leaving the shortcut in place. William felt anger turn into determination. William's group started doing something simple but powerful. They began tracking these cases and sharing summaries with neighbors. They wrote respectful letters to editors and local officials. They attended public meetings and asked hard questions about policy. They couldn't control judges, but they could control awareness. Now we move from stories to action because you need a plan. You can't fix the whole system alone, and that's not your job. But you can protect yourself, support transparency, and reduce risk. Small actions from many people change incentives over time, and your voice matters more than you've been told. Here's exactly what you need to do. I'm giving you 5 steps, and each one is simple. You don't need to do everything today, so don't feel overwhelmed. But start with step 1 this week, because time matters. Write these down, then share them with someone you trust. Ready? Let's begin. Step 1. Set up a simple news habit focused on your federal appeals court. Search your circuit name plus excessive force once each week. Save the links in one folder so you can track repeat patterns. If you see a Supreme Court remand, watch what happens next closely. This helps you spot new words, same outcome tricks early. Do it by Friday because a deadline can arrive without warning. Step 2. If you or your family faces a serious stop, document everything safely. Write the time, location, badge numbers, and witness names you can confirm. Ask for body camera footage through the local public records process. When you request it, say you want all video, audio, and dispatch logs. Store copies in 2 places, like a drive and a trusted relative's folder. Good records can prevent your story from being reduced to 1 sentence. Start building this habit now, before you ever need it. Step 3. Talk to a local civil rights attorney early, not after months pass. Ask about time limits for claims in your state because they vary. If money is tight, ask about legal aid clinics or law school programs. When you call, say, I want to understand deadlines and my options. Early advice helps you avoid mistakes that courts won't forgive later. It also helps you choose a safer path than guessing online. Make one call this week, even if it's only an initial consultation. Step 4. Support accountability at the local level, where many policies are written. Attend one city council or county meeting each month if you can. Ask whether officers are trained to avoid risky tactics around vehicles. Ask how often deadly force is reviewed by independent investigators. If you speak, keep it calm, short, and focused on safety for everyone. Local policy can reduce harm long before any case reaches high courts. Put the next meeting date on your calendar tonight. Step 5. Use your civic power even if you feel tired of the noise. Vote in local elections because judges and prosecutors shape daily outcomes. Serve on a jury if you're able, because real justice needs real citizens. Support groups that track court compliance and publish plain language summaries. If you donate, even $8 monthly can fund records requests and reporting. This is how you turn anger into steady pressure that lasts. Start with one small commitment and keep it for 3 months. Let's review what we covered today. You learned how lower courts can dodge clear guidance with new wording. You heard how automatic rules can replace real, case-by-case judging. You saw how this can block accountability and weaken protections you rely on. You also got 5 practical steps to stay informed and reduce risk. In one region, one shortcut can spread to thousands of future cases. You now have information worth real money and real peace of mind. Here's the final punch you need to remember. Rights don't disappear all at once. They shrink in quiet paragraphs. Most people notice only when it happens to their family, but you're noticing now, and that gives you an advantage. If enough people watch and respond, courts feel that light. And sunlight changes behavior faster than you'd think. If this helped, here's what to do next. Subscribe so you catch the next update before a deadline passes. Share this with someone who trusts you, not someone who argues online. Comment your state below because your location changes the legal landscape. I read comments and respond when I can because patterns matter. Your engagement helps others find this before they get blindsided, and that can save families from years of pain. Important disclaimer, this video is educational only, not legal, financial, tax, or medical advice. Every situation is different, and laws can vary widely by state. Consult licensed professionals like attorneys, CPAs, financial advisors, or doctors. Don't make major decisions based only on this video or any single source. What helps one person may not help you, so get personalized guidance.